Dr. Molteni and Attorney Laubin will be speaking about the intersection of ethics and legal considerations of ABA in schools. So thank you both very much for being here, and we are ready when you are.
All right. Good morning, everybody. It's been a day. We're ready. Talk about ethics and the law because that's how you want to end a Friday, which is great. So I did a little peeking at some of the attendees at the conference today. So I see many familiar names. So I'm happy to see you all. Hello to those who I've worked with before or who were students of mine in the past. I appreciate that. So I am John Molteni. I am a visiting associate professor here at Southern Connecticut State University. I am been in the field of special education and behavior analysis for around 30 years now. 20 of those years have been spent in Connecticut, working with school districts as a consultant. I actually started my own school at one point and spent a lot of years teaching. So I've been also very fortunate to be part of the growth of behavior analysis in Connecticut, whether it's autism insurance coverage for ABA services, certification, licensure, and sort of the move forward in the professionalization of behavior analysis. So we're here today to talk a little bit more about that professionalization and directions we can take. And I'm thrilled to be presenting with my colleague, Michelle Laubin, who I've known for most, if not all of those 20 years in Connecticut.
Good morning. Hi, everybody. I'm Michelle Laubin with Bircham Moses. I'm a school attorney, and I've been practicing in Connecticut for 27 years. So, John, you have known me for all of those 20 years, believe it or not. And yeah, when I graduated from law school in 1996 and started immediately practicing law representing school districts in Connecticut, we were very confused as a legal profession, I think as an educational profession about even what ABA was and what role, if any, BCBAs were going to play in school systems. So it's been quite an evolution over that period of time. And I do want to thank the conference presenters and John for having me at this conference. I may be the only attorney presenting this morning, right? And apologies for being the legal piece at the end of your conference. But John and I kind of stumbled onto some issues around ethics, and I think this is going to be important information for the group. So thank you.
All right. So just a little bit of a disclaimer to start. Nothing in this talk should be considered legal or ethical advice for any specific situations you may be dealing with. So just know that we're having a general discussion about the direction for better defining the role of behavior analysis in schools and practice of behavior analysis in schools. And this is really to help both the behavior analysts and administrators who are joining us today. So welcome to you who are administrators, because it's very important that we really understand what it is we are asking of our behavior analysts. And also, as we've heard from our previous two presenters, the need for systemic supports for behavior analytic practice in schools. Okay. The opinions here are those of Michelle and myself. We have talked a lot about this over the past several months, and we will try to save some time at the end for questions. So please use the QA feature to ask those questions, and we'll try to save a few minutes at the end to answer a few of them. All right, so as Michelle mentioned, how did we get here? Well, we've had some, as she said, tricky or sticky situations, shall we say. But, you know, just in the reactions, give me a thumbs up or an oh no face or whatever appropriate emoji works for how did we get here? And sometimes or most times the role of behavior analyst in schools is that of the emergency responder, right? The come help me kind of thing. Sometimes it's consultation to the team. You're known as the behavior person. You're there to do the FBA and write the BIP. And as I was thinking this morning, I thought, well, we never say FBA, we say BIP. I'm not sure why that is, but that was just a random thought I had this morning. It's not really important unless your FBA is FUBAR, in which case you can look that up and see what that means.
I do hear FUBA a lot, John. So
okay, there you go. For the functional part, but
yes.
yeah, FUBAR is probably more like it in some cases. Milieu oversight and training within specialized programs. So some of you may work in districts where you have in-district specialized programs and you're sort of in a self-contained setting and you are providing oversight and training and support to a program, including the development of instructional strategies or objectives in collaboration with the school team. So some of the risks that, again, Michelle and I have run into recently is some of these, the appropriate consent for services that we're providing. Are we getting consent for services that we're providing when needed? Also, is consent necessary for some of the services that we might provide? Again, our previous speaker spoke about a lot of other opportunities for behavior analysis in schools that would be appropriate and may not require consent. But certainly there's a risk there, particularly if you're in that call me when you need me kind of conundrum. Some of the other risks, direct service versus consultation. I'm not sure if any of you provide any direct services, but most of the times in IEPs, we're listed as consultation to the team, and that consultation may or may not be well defined. And then again, if you're the behavior person, you may be a part of or separate from an interdisciplinary team. So how much of that time or how much of your role is really collaborative with regard to the team, or how much are you sort of called in to be the person who essentially takes that role of establishing an FBA or a BIP. So here are some threats to ethical practice, threats that you might already be experiencing that really can be challenging for both you to maintain behavior. Again, of course, that behavior is up to you to keep, but it's really a challenge in some cases. And the first one really, again, I think we had a lot of sort of thumbs up and amens and claps for, or someone's life was literally being called to take a look at a student, usually in crisis or engaging in some type of challenging behavior. And can you do that, and doing that off the cuff? Obviously, we're going to get into why that's a major issue, but I think you can see that. I think oftentimes we're seen as the easy button, or in this case the help button. And most of the time that motivation is negative reinforcement. It's help to remove this problem from us, as opposed to being more of a collaborative problem-solving process. I was in a school the other day and I was asked, and when I get involved, by the way, in a school, it's gotten bad. I mean, I don't come in the proactive, helpful part of the process. I come in and the attorneys are involved. Could you please come in and help us resolve the issue kind of problem? And the question I was asked was, what should we do when the student starts aggressing to their peers? And I kept saying, I don't know, because I didn't know. And frankly, it was the wrong question, right? Because the question is, how do we build systems? How do we develop support programs to ameliorate the need or the type of behavior that student is engaging in? In many cases, disconnected administrative structures. So you might have a director of pupil services, student services, special education director, whatever the term is, who may be very supportive of your practice, but principals may not understand exactly what your role is, or the superintendent might not, and so you don't have sort of this top-down organizational support for the practice of behavior analysis in your schools. And again, just referring back to our previous two speakers, right, their success has come from that level of administrative support. And so we'll talk a little bit about that later, just in terms of supporting and advocating for behavior analytic practice in schools. So if you're an administrator here, thank you for being here, and I hope you're one of those folks who are going to support the continued use of appropriate and ethical behavior analytic practice. I don't know if anybody has an excessive caseload. Probably not, I'm guessing, so don't bother responding. But oftentimes we do have these caseloads that are sort of well beyond the capacity and necessary for us to, again, really start to focus on what it is that we're talking about, right, in terms of the workload that we're doing, capacity, and differentiating between a caseload and workload, which I'll talk about a little later. Again, as some of the presenters mentioned, a lack of support for behavioral analytics services. So district-wide or school-wide, you may be coming in, you may be working with people who either don't agree with, don't understand, or don't want your services or want to do behavior analytic services, either from a position of what we do or what it is, or just us being, in some cases, maybe stepping on toes, right? The stay in your lane comment from the previous talk was relevant. And then finally, a lack of clearly defined structures for support and prevention, right? Again, which we've talked about, the PBIS, multi-tiered systems of support, response to intervention, whatever framework you're talking about, all of these provide a level of support and prevention. Without those, again, it becomes we are consistently dealing with more challenges. We're dealing with tier 3 interventions. We're dealing with hierarchies of challenging behavior once it's gotten to a critical mass, as opposed to preventing it from the beginning. Recently, there has been, I will say there's been one, at least that we're aware of, attempt to create some guidance for behavior analytic work in schools. That was in Virginia. I'm sure we will be sharing some of these links with you later, but if you can look up VA Public Schools Behavior Analyst Network, and you can find this information. And this was based on a legislative mandate to actually put these things together, which is wonderful, and they have some standards and they have some guidelines. And I think that's a framework that can be generalized or generated, which we'll talk about a little bit later. And maybe comment a little bit on some of the structures that we're looking for. But this is a good step, at least, for acknowledging that behavior analysis is a profession now in the school, and it's something that we need to really look at and ensure that we are addressing appropriately. All right, now I get to turn it over to the fun legal stuff. So.
All right, so I'm going to talk about a little bit of the legal framework that you all are operating in if you're working in schools. And just as a caveat, as I mentioned earlier, I am an attorney that's practicing in Connecticut. So you'll be looking at citations to the Individuals with Disabilities Education Act, which is the federal law that governs provision of special education and related services. And I did put in our Connecticut state regulation citations in here too, because that's what I'm familiar with, and some of you will be familiar with this. But just as a caveat, if you're in another state, you'll want to look at your state's regulations, obviously. And they do vary from state to state. Different states have different approaches. Some go well beyond the IDEA and are more protective of parent and student rights than the IDEA requires. And some just sort of stick with the basic IDEA requirements. So you'll want to find out what kind of a state you are practicing in. Just by show of, I don't know, hands, reactions, whatever, how many of you have actually had a training, like a legal training on the IDEA and its requirements? I won't stop and wait for your responses, but I'm hoping that that's becoming sort of part of the behavior analytic training, either pre-service or in service. And if you haven't had that training, I would definitely encourage you to seek that out, because this is going to give you a very high level, pertinent to the ethical issues that we're talking about, but you'll need a lot more information than this. So the first thing I want to talk about is the IDEA child find requirement. And where this becomes an issue is when we have a student who is not yet evaluated and identified as a child with a disability under IDEA and does not yet have an IEP. So the child find requirement is the requirement that all states who accept IDEA funding, and that's all of them, must have policies and procedures in place to ensure that all children with disabilities residing in the state, regardless of where they are located. So this could be students who are still at home, and IDEA is, generally ages 3 to 21, 22, depending on what your state requires, are located, identified, and evaluated. And then we have the citation to the Connecticut state regulations that require compliance with the IDEA child find requirements. And those citations are to the regulations of Connecticut state agencies. So we can go to the next slide. There we go. And these are our state requirements. We actually go above and beyond the IDEA here a little bit. So we have some regulations that say specifically we need to promptly refer to our planning and placement team, which is our IEP team, all children who have been suspended repeatedly or whose behavior, attendance, including truant behavior or progress in school, is considered unsatisfactory or at a marginal level of acceptance. When we have a student who is exhibiting these very high level behaviors, they're very disruptive, they're very dysregulated, and they're not yet identified, right? The school's responsibility is to refer that student to the IEP process for evaluation. And as we'll see, the responsibility here is not just around conducting a functional behavioral assessment, although that can be part of an initial evaluation process, but there is a comprehensive evaluation requirement under IDEA. And what we start to see is, because of the preference for SRBI, scientific research-based interventions, and sort of that early intervention process, we often see roadblocks to referral to the IEP team process. Or we're trying to take care of things before they get to the point of identification of a child with a disability. So there's going to be this tension, right, between we have a child whose behavior is indicating they're not able to comply with the basic classroom requirements. Now, when do we need to refer them to the IEP team? We also have in Connecticut that if a child is receiving SRBI interventions and a referral to special education is received, the district must accept the referral and shall convene a PPT meeting to consider the referral to determine if an evaluation of the child is appropriate, and also continue the SRBI during any evaluation process. And again, your state may operate differently, but that's the rule that we have in Connecticut. We can't say, no, we won't have an IEP team meeting if we receive a referral to special education, and our staff has sort of a proactive obligation to refer the student to the special education process if it falls into one of these categories. And we can go to the next slide. Once we get to the IEP team, now we have to design, as I said, a comprehensive evaluation. So the school district must use a variety of assessment tools and strategies to gather relevant functional, developmental, and academic information about the child, including information provided by the parent. So the parent input is a huge part of this evaluation process. And if we don't have parent input, that can actually sort of invalidate the whole evaluation process. And that evaluation, that initial evaluation, has to do two things. So we have to, number one, determine whether the child is a child with a disability under IDEA. So that's the identification piece. Does this student qualify for special education services? And then if they do, the second piece of that is to determine the content of the child's IEP, including information related to enabling the child to be involved in and progress in the general education curriculum. So you can see already, I think, from the behavior analytic lens, you're going to be thinking about, well, am I even part of the initial evaluation process, right? Is my piece of this going to enable the team to either determine whether the child qualifies as eligible for special education services, or B, if the child does qualify, what should be in place as part of that IEP. And I find that, I love my school folks, and they tend to focus completely on the academic piece of things, right? They want to know whether or not the student is keeping up academically, or what the sort of academic achievement test scores look like. But we also need to focus on that secondary piece of other aspects of access to the general education curriculum. Are we able to comply with the social emotional requirements of the classroom? Are we engaging in the classroom? So all of that has to be part of adverse effect on educational performance. And if we don't have the information relating to a possible behavior intervention plan that the child may need, then we may be missing that piece for the content of the student's IEP. So we'll want to make sure that we have that piece. We can go to the next slide. So in the cases where we've had some ethical challenges, and I know we're gonna address this as we go through repeatedly, but one of the things that keeps coming up is, what if we have a student who is really struggling, is very dysregulated, but also seems to be acquiring academic skills at the same pace as his or her peers? And at what point do we refer that student to the IEP team process, and or can we do what we've come to call the standalone FBA, right? At what point, if at all, do we do a standalone FBA? And this can happen in places where the parents are not in favor of the referral to special education. They sort of like what's going on in general education, or for whatever reason, they don't want their child labeled. And so they're resisting that referral, or you're going to that initial process and then they're saying, no, 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 we don't want to consent to that initial evaluation. One of the things that's in the IDEA that we keep coming back to is this prohibition. We cannot use any single measure or assessment as the sole criterion for determining whether a child is a child with a disability or the appropriate educational program for the child. And I think that this arose initially out of a tendency to sort of do an IQ test and decide whether or not a child was eligible for special education services based on an IQ test. But it also applies to any other single measure that we might want to use. So if we do an FBA, we can't use just the FBA to decide whether or not that student is a student with a disability. We also have to use technically sound instruments that assess the relative contribution of cognitive and behavioral factors in addition to physical or developmental factors. So that speaks to that, that need to expand the evaluation and to be comprehensive in evaluating all suspected areas of disability. I think we can go to the next slide. And here we have the language around, this is sort of a summary of the language around comprehensive evaluations under the IDEA. So the child must be assessed as part of the initial or the triennial evaluation process in all areas related to the suspected disability, including health, vision, hearing, social and emotional status, general intelligence, academic performance, communicative status, and motor abilities. So you can see again how, even if behavior is the area that is presenting itself as the primary issue interfering with the student's educational performance, it should not be the only thing that is assessed. You kind of have to ferret out, like, are there any other factors that are contributing to that behavior in order to get a global picture of the child's level of functioning. So the evaluation must be sufficiently comprehensive to identify all of the child's special education and related service needs, whether or not commonly linked to the disability category in which the child has been or may be classified. So we don't do, one assessment for a child that we think may have autism and sort of stick to that evaluation pattern every single time. We want to talk about what are this child's unique needs and how does that evaluation look for that child. We don't have a different evaluation for children that we suspect may be cognitively impaired. Although the assessments may look different, we want to make sure that they're individualized. We can go to the next slide. Okay. And then we need written consent for that evaluation. So once we've succeeded, hopefully, in outlining what is the comprehensive evaluation, and it's going to go beyond the FBA, we have to get written parental consent in accordance with IDEA for any initial evaluation, reevaluation, and for initial receipt of special education and related services. And if this falls apart at any point in the process, we can't proceed. Right? So this is the basic framework. Now, we're going to talk about how you layer on top of that your ethical requirements as a BCBA. And this is where we're sort of presenting a challenge that has to be resolved, because the failure of the parent to respond to a request to conduct an initial evaluation, reevaluation, or the initial receipt of special education and related services. Again, this is a Connecticut regulation, so your state may vary. But in Connecticut, if the parent either says no or doesn't respond within 10 days from the date of the notice to the parent, that is construed as a refusal to consent. So we have had cases where we have presented this comprehensive evaluation plan to the parent proudly and said, this is what we need to do to determine eligibility for special education services. And the parent says, no, thank you. Or you do the evaluation, they give you consent to do the evaluation, and you say, great, your child is eligible for special education services. And they say, no, thank you. We don't want those services. And then the question becomes, well, now what, right? Because we still have a child who's dysregulated. We still have a child who is acting behaviorally in a way that's interfering with their learning or the learning of others, and sometimes both, and we still have to respond to that. Well, we can go to the next slide.
If you are interested in using this presentation for CEUs, please get ready to write down the first passcode. The first passcode is 2462991.
So the question becomes, legally, is an FBA an evaluation under the IDEA? And we actually had this case, and this case was handled by our firm on DS versus Trumbull Board of Education. It went to the Second Circuit Court of Appeals in 2020. And in this case, and I'll spare you all the details, but one of the issues was that the Second Circuit had to discuss what constitutes an evaluation under the IDEA. Because remember, it's the evaluation that requires parental consent, and that also has implications for whether a parent can request, if they disagree with your evaluation, an independent educational evaluation at public expense. So this case really had to do with that second question about whether or not the parent was entitled to an independent FBA because they disagreed with the FBA that had been done by the school district. But in order to answer that question, the court first had to decide whether or not an FBA was an evaluation. And in this case, it was the standalone FBA, right? So it was not part of an initial evaluation. It was not part of a triennial reevaluation. And the court held that in that context, an FBA is not an evaluation for which a parent can seek an IEE under the procedural safeguards. So then we get to, and this question was not addressed by the court, right? If it's not an evaluation, then do we need consent for it? And in Connecticut, we have adopted this practice, and this is not in a regulation or anywhere else that I'm aware of, but it is the interpretation of the state of Connecticut that we have this practice of calling these things that we do that are individualized to a child. In other words, they're not benchmark assessments. They're not part of the general education process. They are part of the special education process, but they're not an initial evaluation and they're not a reevaluation. We are calling those targeted assessments. And the reason for that is that they still require parental consent, even though they're not an initial evaluation or a reevaluation. So in our electronic IEP system now, we now have different consent forms for the initial evaluation, the triennial reevaluation, and then we have these targeted assessment forms for parents to sign off on if they're giving consent for a targeted assessment. You can see, I think probably already, the problem being if you don't have a student who is identified as eligible for special education services, right? You're not doing a targeted assessment. By definition, you're doing an initial evaluation. So if you end up in this debate over whether or not an initial evaluation should just consist of an FBA, or you want to do a standalone FBA, that's going to become problematic when you think about what I just talked about in terms of the need for comprehensive evaluations. So we can go to the next slide. And this is the IDEA requirement for consent for initial placement in special education. This is anything that you see that is CFR is the Code of Federal Regulations, and this is the section that pertains to IDEA. A public agency that is responsible for making FAPE available to a child with a disability must obtain informed consent from the parent of the child before the initial provision of special education and related services to the child. In Connecticut, we only require consent for the initial placement in special education. We don't require consent for every IEP after that. And I know there are other states that do require parental sign off on IEPs. We are not one of them. And then if the parent refuses to consent or does not respond, the district is not permitted to start due process to obtain consent to provide services. Now, this was a change that was made to the IDEA. We used to be able to start a due process hearing if we thought that a child desperately needed special education and the parent wasn't giving us consent. We are not permitted to do that anymore. The one concession that they gave us under IDEA is if the parent refuses to consent, we're no longer responsible for providing FAPE to that child. That doesn't help us a whole lot. However, if we have a child, again, who's very dysregulated and is really struggling, what do we do? So if we go to the next slide, we have one other possibility, and that is Section 504 of the Rehabilitation Act, which is a federal law that protects individuals with disabilities from discrimination. It's part of the Rehabilitation Act of 1973. And essentially, it says that no qualified handicapped person shall, on the basis of handicap, be excluded from participation in, be denied the benefits of, or otherwise be subjected to discrimination under any program or activity which receives federal financial assistance. This is what leads to a Section 504 accommodation plan, because the purpose of the 504 accommodation plan is to prevent the individual from being discriminated against. If you go to the next slide, the eligibility requirements under Section 504 are to have a physical or mental impairment which substantially limits a major life activity. So if you don't have IDEA eligibility because the student doesn't require special education services, or you do and the parent won't give you consent for special education services, the question becomes whether you try to serve that child under Section 504 instead of IDEA. Now, I will tell you that there is a huge debate in the world of education about whether or not this is a good idea, because obviously you've just decided that this child needed special education services in order to receive FAPE, and now you're going to provide them with something that isn't that. And there used to be a rule, a very clear, bright line rule, that if you had offered an IEP and the parent said no, you were no longer responsible to offer them a Section 504 plan in its place. That bright line rule has sort of been abrogated by a series of court decisions across the country, which I don't have time to get into today, but just know that this is sort of a plan B that might be accessed if you find yourself in this situation, and you're going to have to look to your administration for guidance about how to do this. There is such a thing as protections under Section 504 for having a history or record of impairment or being regarded as having an impairment, but just know that only the presence of a current impairment requires the development of a Section 504 plan. And then if you go to the next slide, you can see this is the reevaluation or initial evaluation process under Section 504 is not nearly as well defined as IDEA, but generally speaking, if you follow the same process under Section 504 that you follow under IDEA, the U.S. Department of Education considers that to be sufficient procedural protections for the student and the parent. So you are still going to have to do an initial evaluation. Hopefully you've already done that under the IDEA process, and you can use those evaluations to decide whether or not the child has a physical or mental impairment. And then you may be able to implement a behavior intervention plan under Section 504. If the parent hasn't given you consent for the IDEA evaluation, you may be able to do an FBA under Section 504 and get consent for it through the 504 evaluation process. So this is where, again, we have to talk about what the ethical considerations are that apply specifically to you as BCBAs. And I'm going to turn it back over to John to go on to the ethical considerations.
All right, thanks, Michelle. Just so you're aware, every ethical guideline is important. So I don't want any of the ethical guidelines to feel like I'm leaving them out, or that they're not important. But I think considering some of the more important things that are relevant to our practice and remaining ethical is really thinking about how we are communicating about the services that we're providing, being truthful and accurate in what we're doing, how we do it, how it's supposed to look, how much support's going to be needed. And this will sort of be layered throughout some of the other conversations we'll have. Practicing within your a defined role is very important. Again, understanding what is the role of a behavior analyst in a school. What are we supposed to be doing? When we're in a milieu type of situation, is that role better defined in terms of how we're supporting behavioral supports or staff training or those types of things versus a consultative model where someone may be hired by a district, but they're floating amongst a number of different schools. Again, those need to be defined very well as to what is expected of you and what you're able to do. Now, if you're consulting or you're in a clinical setting, those are usually contractually related. If I'm going into a school, I have a contractual obligation. I define very clearly what it is I'm going to be doing in a school. If you're hired in a district, you should also have these conversations with your administrators about what it is that I can do or what I'm able to do, what I'm supposed to do, and then how that is supposed to be implemented in given caseloads and schools and coverages and things like that. Of course, practicing within your scope of competence, right? In a school setting, you may be faced with many situations, many different populations of students or presentations of student difficulties at various grade levels and age levels that you may not have experienced as part of your initial training. And that is what it is. Schools accept the kids who are in there and catchment areas, so you're going to have the kids that come to the door, but you need to be clear as to what your training has been, what you're competent in working with, and again, this will come into effect a little bit later. What supports might you need, or professional development might you need in terms of supporting the students that are presenting within a different district and in your district. Collaboration, always in the best interest of the client, as some of our previous presenters spoke about. You don't always have to be the authority. Don't be the stuffy scientist person who talks in behavioral terms all the time. But you have to be able to talk to these folks, listen to what they have to say, appreciate and honor their experience and expertise. And so collaboration can be hard. We are, again, very much a newer discipline within the schools, and generally speaking, as we've seen in much of our professional documentation and reporting, a very young profession. The majority of people within sort of their first 5 years of certification going into schools that are complex systems. So you're at very much a disadvantage going in if you're the behavior analyst or one of a few in a district. So And then, of course, obtaining informed consent. Again, with role definition, what it is that we're supposed to do, what we're supposed to do, and then working with specific students. Once you sort of get that, I'm working with this student, you really should be thinking about consent, because generally you're going to be doing an FBA or a BIP, particularly around that area. And I've heard these stories. I'm sure Michelle's heard these stories. I'm sure you've heard these stories of someone, right? Maybe you've been asked to go look at a student. And imagine just the communication to a parent when a principal calls and says, your child had some difficulty in school today, but don't worry, we had our behavior specialist come look at them. Or the student goes home and tells their parents that, oh, so-and-so, this person came and spoke to me today. And you don't have consent and you don't have that type of protection, right? That's communication. That communication is critical. So I often tell people, and I've told my students this, you may have heard this, if you're a student of mine at some point, don't be helpful. And I don't mean that in terms of don't do your job and don't be a support person. But we don't give advice. We're not advice givers at this point. We're behavior analysts. And so until you've done the appropriate levels of assessment to support the students, unless you know about that student's circumstances in terms of the comprehensive evaluation and one's ability, and what are those barriers? You can't write a behavior plan without context. And so don't be helpful as an advice giver. Be helpful to your friends on Facebook, social media types of things. You want to give advice, great. Anyway, I won't go on about that. I have limited time, so I must keep going. Accepting clients, in this case, accepting students, finding an appropriate caseload, okay? And again, differentiating between what your caseload is and what your workload is. One of the things that Michelle and I talked quite a bit about is we talked about the role of behavior analysts and how sometimes in an IEP, which I believe Michelle can comment on this a little more, the state hates, up to, consult up to X number of hours per month or something like that. Or just saying consultation to the team 1 hour a month, or maybe just say consultation to the team, right? Your workload doesn't just include the time that's listed in the IEP, right? The hour a month, or I don't know how you do things with an hour a month, but that's besides the point. 10 hours a month or whatever it is. It's also about the paperwork, the meetings, and all the other stuff, and that's really your workload. And so we don't have good definitions for those things. Hopefully that's something we can clarify, but it is something that we need to talk about, or you all need to talk about. Documenting your professional activities, write everything down. If you consult with someone, write it down. If you're having a training, write it down. I always tell my students, and because I've been to multiple due process hearings, assume at some point you're going to go to court with this. And so you need to document everything that you have done in terms of supporting, meeting the requirements that are outlined in the IEP or whatever your roles are. Okay. And then lastly, advocating for appropriate services. We need to be able to talk about what it actually does it require to function either within a comprehensive educational program. Within that context, how does this behavioral support work? What is your role as it relates to the time it takes to do the assessment, to write the behavior plan, to implement that behavior plan, which is what we're going to be talking about next, because we have to be able to do these things well. Providing supervision. Right, we're developing these procedures. We develop a behavior intervention plan. Again, this is one I'm not going to ask you to raise your hand for, because it's being recorded and someone may call it up but if you've ever written a behavior plan and then just handed it over to the team and haven't followed up with training and ongoing progress monitoring, please don't raise your hand. It may have happened. It probably is something that it shouldn't happen. It can happen. Again, thinking about both ethical and then from a legal perspective, if you're an administrator, you want to make sure that your behavior plans are being monitored and changed. And when I see behavior plans that haven't been changed for 3 years or are based on a behavior FBA that was conducted 3 years ago, these are problematic things. So these are barriers, right? You're overworked. I understand. I get it. I'm on your side here. I'm not trying to be the ethics police and say, get your stuff together. But we need the support of a system in order to do that. So you need to be able to progress monitor, give feedback, and only delegate those things that people are capable of before delegating responsibility. So if you're not able to train paraprofessionals, behavior technicians, RBTs, whatever you have, whatever personnel you have to support in the district, or working with a school psychologist or a general education teacher, whomever, whoever's going to be taking responsibility for that, right? Remember, your name is on that plan, right? Your name is on that FBA and behavior intervention plan. And so taking responsibility and ensuring that people understand what does it take to do these things is really important. All right. Sort of like if a tree falls in a forest and no one's there, does it make a sound kind of thing. If you develop a program and no one's able to implement it, you really haven't developed a program, right? You've met some benchmark of potential compliance with the law, but that's going to be a hard thing to defend in court. And the other thing you need to remember is that when they call in for the due process hearing, the expert witness, it'll probably be someone like me, another behavior analyst who's going to say, you know what, nope, you didn't do what you were supposed to do. So I want to be your advocate. I want to help you. I want to support you in doing this. So don't put me in that position. It makes me uncomfortable because I like you. I like you all. I don't know many of you, but I feel like I would like you all. So, all right. So how do we start? How do we start being ethical? Start with your scope of competence. Know what you're good at. Know what you need to professionally develop. Again, scope of competence is your training and experience. Here's what you know how to do. Here's what I've been trained how to do, right? What don't I know how to do? I don't know a lot of things still. I've been doing this for a very long time. I've learned a tremendous amount from the people I've worked with, people like Michelle, about law. And I don't know. You don't have to be an expert in everything, but you do need to know enough to not get into trouble. Okay. Define your role. What does your job description look like? I remember Shelby and Kelly spoke about the other duties as assigned. I know those are probably hard to get out of a job description, but put some limitations as to what you can't do. Here's what I do. Here's what I don't do. I said do, so there you go. It's Friday. All right. And then you're educating about ethical standards. That means talk to your administrators, talk to your principal, talk to people who don't know what we do, because people don't know what we do. And so we have to educate them. Here's our ethical standards, right? So hand it to them so they can follow along, but don't expect them to read it and understand it. You have to explain it to them. And then finally, define your role in the IEP. How much time you need to support the team, right? How much do I need to train? How much do I need to do this? And then obtain consent for your stuff. All right, we're running out of time here. I want to make sure that we get to everything and also maybe have a minute for questions. All right, how can you get involved? Again, we've heard previous presenters, our 3 tiers of support. Again, if you need to learn about them, learn about them. You can train staff on behavioral principles. You can collaborate with professionals, right? You can direct people as to the proper approach to, if you need my services, happy to help. Here's what you need to do. You got to talk to so-and-so, or I'm happy to sit in or talk about this, right? But, again, I'm not going to give advice and I'm not going to start consulting on a case until I have proper consent. And always look out for the paraprofessional, behavior technician, and RBTs. I heard a horror story in class at one point where one of my students came and said a paraprofessional was asked to do something, they don't have training or they're not licensed to do anything. So, don't do that stuff. Oh, it wasn't by you, by the way. It was by somebody else. All right. And if you don't know, ask. There are plenty of places you can look for information. Your state professional organization, find a mentor, talk to a faculty member if you like them from your program, talk to them. If you don't like them, talk to a different one. There are faculty members in your state somewhere, talk to them. And there's the ethics hotline. You can do this proactively.
If you are interested in using this presentation for CEUs, please get ready to write down the second passcode. The second passcode is 758413.
Okay. And then what types of professional development can you look at? Well, obviously, special education law is the number one. If you haven't had it in your pre-service training, get it now. Multi-tiered systems of support, PBIS, get educated about it, interprofessional collaboration. Again, this is not an exhaustive list. These are just areas that you can think of: universal design for learning and evidence-based instructional practice. I actually took a course in reading at one point, not because I wanted to become an expert in reading, because I wanted to understand what reading teachers actually teach. Couple things that we're looking for in terms of clarification would be great. Do we need to have separate consent for BCBA's involvement in milieu programs? So if we're providing services in a self-contained classroom or some other type of setting, do we need separate consent? That would be particularly problematic, by the way, but we don't have time to really get into that. Again, defining competencies for working in schools would be helpful. We're starting to look at those things. Again, we have some one state that has looked at some guidelines for it, and it did a little crosswalk of both the ethics guideline and the task list. But really, what is unique to school behavior analysis? Much like school psychology, I'm a clinical psychologist, and school psychology is a separate field because it specializes in school programs. What organizational structures are needed to support ethical and effective behavior analytic services? That's our administrators. We need top-down support. You can't do this by yourself. It's hard to do it by yourself. You can be an excellent behavior analyst. People might love you as a behavior analyst in the district. It's going to be really challenging to do that without additional support. And then legislation would be great to help support the guidelines for behavior analytic practice. In Connecticut in 2021, they just published guidelines for the practice of school psychology. So maybe behavior analysis is next. That would be great. We think certification of behavior analysts within the State Department of Education would be helpful. Hopefully, in your state, I don't know, I haven't seen any states that actually do this. We are licensed in 37 states, but we don't necessarily have this. That also, at least in Connecticut, offers opportunities for leadership certification, right, as opposed to taking another profession. So that's one thing to think about. All right, that is, I don't know if we have any time left, but this is our contact information. If you'd like to email us and ask us a question or give us some feedback or have some comments, obviously this probably would make for a, could be a 3-hour workshop if in terms of content, but we're really glad to at least start to have this conversation about more clearly defining the professional role of behavior analysts and the practice of behavior analysis in schools. So I appreciate your kind attention for a Friday, and hope you have a wonderful weekend. And thanks for coming.
Thank you so much, John and Michelle. I do have one question in the Q&A that came up several times, if you have a minute to answer. Just one.
I do. If
Great.
it's for me, yes. If it's for Michelle, I can't speak for her.
maybe for both of you. So this question was asked a few different ways, but the question is, does a student have to have either a 504 plan or an IEP in order to have an FBA?
Well, I can start on that, and then John can weigh in. I think that the answer to that question is very unclear at the moment, but in Connecticut, the practice seems to be to allow both FBAs and BIPs to be put in place without either an IEP or a 504 plan in place. I think the ethical concern is that it's my understanding, and John, you can jump in here, that BCBAs do need consent in order to proceed with an FBA. So if we as a school are doing something, we're doing an FBA without an IEP or a 504 sort of backdrop to that, and it's not under one of those processes, what is the process for obtaining consent, right? I'm fairly confident in saying that we would not ask or want to ask a BCBA to do an FBA without obtaining parental consent. And should we be asking other folks to do those FBAs. There's training that's being offered to school psychologists, to social workers, to a lot of different folks, to multidisciplinary teams, and doing some type of FBA leading to a behavior intervention plan. But this seems like a very unclear framework for me. And I think, it's increasingly becoming apparent that it's unclear ethically for BCBAs as well.
Yeah, I certainly would agree with that. The conflict, if you're at your, let's say your tier 3 intervention is supposed to be an intensive, individualized intervention, and if you're functioning within that framework, an FBA would be recommended. That's not how we can't operate, and essentially without one, it's hard to do that. But the other piece that we were talking about with regard to the comprehensive evaluation is I can do an FBA sort of in isolation without understanding all of the vulnerabilities of that student in terms of their language abilities, their cultural framework, their academic achievement, their social emotional development, those types of things. And I'm just saying, well, look, it's escape maintain behavior. Okay, well, in what context is it escape maintain behavior? It's helpful to have that interdisciplinary team, and we need to leverage that interdisciplinary team as a behavior analyst to really understand what the challenges are. So, if we happen to get to that point, and I would still say, consent for sure at that level. But again, is there a mechanism for that legally is a whole different question. So, it's very much a conundrum apparent at this point, which is, we need clarification on that.
Okay. Michelle and John, thank you very much for joining us today and sharing your expertise with us.